welcome Yuval, and we'll launch into this US-Mexico education, knowing about rights, and a fabulous paper. So Desiree, you go ahead, 10 minutes, Yuval, 10 minutes, and then we'll open it up for discussion, okay?
Sounds good. Thank you, Guy. And thank you, Hila and Yuval, for engaging with this and the invitation. And thank you all for coming today. This was a very rough draft, so if you slogged through it, I appreciate it. After writing it, I didn't look at it for several weeks because I'm writing these other things. So I just reread it, and I think I finally figured out what it's about, which I don't think I knew when I was writing it. So you know how those
This is
go.
the purpose of our meeting. And by the way, none of us should apologize that we're doing rough drafts or anything, because that's why we're here. And,
Good. Thank
and
you. Thank you for the
it's
validation.
an opportunity for thinking out loud what our project's about. So, yeah.
Thank you. I love that. Okay, so then that's the spirit in which I join you today. So I think what this paper is about as of right now is whistleblowing in trade. And it's premised on this notion that since the 1980s, various trade partners, the United States, the EU, Chile, increasingly governments are trying to regulate global supply chains through their international economic law instruments. And by that, I mean their trade agreements, their preference programs, their forced labor bans. We're seeing increasingly these different legal instruments that are trying to get at labor rights abuses. But the difficulty that's kind of presenting itself, to the surprise of no one, especially on this Zoom call, is one of enforcement and compliance. And the reason why is because the global supply chain, as May and others have been discussing, is quite obscure. And we can't see what's happening. Even those of us in the forced labor space, we hear constantly from various stakeholders how we need more data along the supply chain. And it drives me nuts because what they're saying effectively is we need a mechanism to hear workers' voices. And nobody thinks, well, maybe we should find a way. Except some governments recently, most notably the United States, during the first Trump administration, have begun to use these instruments as a way to encourage private actors, not in their territories, but in the global supply chain territories, a platform to whistleblow, to tell on their employers. And so, the biggest example, I think the first, but I know it's going to be replicated in other instruments, is the US, Mexico, Canada agreements rapid response mechanism. I'm not going to go into a whole lot of detail on that. I feel like most of us are probably familiar, but if you have questions, feel free to ask me in Q&As. The important part for our purposes is that the rapid response mechanism created a platform for workers and Mexican trade sectors to be able to alert the US federal government of violations at the grassroots level, so on the shop floor. And the US government then, armed with this data, this information, is authorized within the terms of USMCA to take direct enforcement action against that facility in Mexico. And so in that sense, it's similar, I think, in important ways to some of the whistleblower legislation we have in the United States and Europe and elsewhere, where workers within sectors are given a platform, given a channel to basically identify problems within their facilities. So this has become kind of an instrument that governments are using to ensure compliance in areas that they don't necessarily have the resources or the bandwidth to inspect themselves. A lot of work has kind of focused on whistleblowing laws and kind of the factors that make them or break them. Yuval or Lee, they've written some really phenomenal things on this, as well as others, showing that while whistleblowing is a laudable goal, it's not to be assumed. That is to say, and this should resonate amongst us, workers aren't necessarily going to blow the whistle against their employers. They need certain things to kind of entice whistleblowing. Elements such as assurances against retaliation, sometimes positive things like monetary rewards, normative rewards, various things that kind of adjust the risk calculus with workers on, do I risk losing my job? Do I risk retaliation in order to whistleblow, or do I keep it safe? Right. So this research has shown that whistleblowing isn't a given. There have to be certain rewards. There have to be certain protections in place in order to entice workers. What I think is happening right now is that the United States and other governments that are giving workers this whistleblowing opportunity, this platform to the ear of trade partners, are doing this without thinking about these instruments as whistleblowing instruments. And as a result, they're not being deliberate in enticing worker participation. So the backdrop of my research is a study that we did in the Mexican auto sector on the effects of the rapid response mechanism on workers. And what we found was a huge disparity between the workers that had certain connections to US stakeholders, and with those connections, certain protections, certain assurances, certain monetary promises, this understanding of what would happen if they had a successful rapid response mechanism case, compared to those workers in the sector without such stakeholder alliances. They weren't as aware. They didn't know what their rights were. They didn't know what the benefits of whistleblowing would be, and they lacked trust in the US government. And looking at the instrument of the rapid response mechanism, we could realize why workers in Mexico, without additional inducements, would be reluctant to use it. So I walked through kind of the factors, beginning with factors that Yuval and Orly have provided us in their work about what type of enticements in the instrument itself might advance worker cooperation. And I compare that to the framework of USMCA's rapid response mechanism. So that is to say, I find that there are protections. So I'll just kind of walk through some of those factors. I find one of the first factors they note is anti-retaliation protections. So this goes to the risk calculus. If you look at the rapid response mechanism, everything is confidential, everything is anonymous. It takes into account the high level of risk that workers face. The second factor they mention is monetary incentives. So sometimes you can induce workers to participate if you have some kind of financial reward. Now, this is a minority. We don't have a lot of whistleblowing acts that have these monetary incentives, but we do have some. And looking at the rapid response mechanism, one could infer monetary incentives, again, by promising workers that should they use the rapid response mechanism successfully, they can end up with higher wages, independent unions, and the like. So these types of factors are kind of built into the design. As far as normative incentives, another factor identified, you can find that workers are kind of told that this is a broader movement of independence within Mexico, that they're part of a greater scheme, and that again can induce compliance. But one thing that I noticed is that these factors are most salient if workers already were informed of the rapid response mechanism and these potential benefits. The issue, however, and the difference between these trade instruments and traditional whistleblowing statute is you have a greater distance between the public actor that's regulating it and the workers that are across border that don't necessarily have access to the information and may have fewer reasons to trust the legitimacy of the regulator. And the rapid response mechanism does not take into account those factors. So after looking at the kind of commonalities between whistleblowing statutes as we know it, and now what we're seeing in USMCA, I point out these additional factors that I think the USMCA should have taken into account, and that future instruments must take into account if the objective is to induce worker participation. So that includes things like antecedent trainings to shorten the distance between the regulator, the regulations, and worker awareness. There needs to be antecedent trainings and antecedent trust building activities if we truly hope to have a worker population that's willing to blow the whistle against its facility, galvanizing enforcement across border. So I think even though looking at the results of USMCA strike me as somewhat depressing. I mean, on the one hand, we are getting participation, and to the extent that any workers participate, that itself is a win. But if you look at who is benefiting, the worker population that is getting the raises, that is getting the independent union representation, those, comparatively speaking, were already the elite workers. They were workers being targeted by US unions. They were workers already with Solidarity Center connections. They were workers within the spectrum of the supply chain that were already fairly transparent and cared for. The workers that are not benefiting under this scheme are the most vulnerable workers. They are in the facilities that are not attracting US stakeholder participation and lobbying. These, I would imagine, are the workers that we want to shed light on, that we want to participate. So the scope of this activity is to continue to encourage this type of instrumental approach, this whistleblowing approach across borders, but more deliberately so, with an eye to educating, empowering, and building trust at the outset. So I'll stop there because I'm far more interested in hearing from you guys than hearing from myself. Thank you very much. Hi, are you speaking? Because you're on mute.
You're on mute.
We never learn, huh? Thanks, Desiree, and we're in your capable hands, Yuval.
Thank you. Thanks for having me. I apologize. I'm actually talking now from Boston. I'm part of kind of a pretty busy schedule, so I could only kind of be in this panel. But I really enjoyed reading the paper. I think Desiree kind of said this is a rough draft. It was a super impressive research on 130 workers, I think, across different something like 10 or 12 facilities. So the kind of the groundwork here and the quality of field research that was done is really impressive. And I'm kind of more a quantitative researcher. I always kind of that's a classical the debate in methodology as kind of the pros and cons of each approach. But I think here you really showed how valuable is this kind of more qualitative work where, again, in some of my own kind of very artificial experimental settings, things are clean and smooth and we can find causality and what factors are more important. But none of what we said will work, right? In what you basically show. And in that regard, I applaud this huge effort. And I think it's really, and this is, before we talked, I thought it was a book, right? Because it was so impressive in the amount of data collection. So I hope at some point it will become part of a book. This is the role of a commentator, is kind of not to say nice thing, but to kind of encourage further research. It will be the nicest way to say it. So you very much I think going in the idea that how to improve whistleblowing. The question is, maybe the lesson is that we shouldn't trust whistleblowing to begin with. So I mean there are with increasing the regulatory policy research suggests numerous tools one can use and examine the pros and cons in each context. And I think you're very right, and you have a lot of nuance findings about the problems with whistleblowing, but it seems you still believe in it, which is fine. But then the question is just, I'm raising the opportunity of maybe thinking of alternative mechanism, because I think to some extent, and this is a very nice kind of Law and Society paper on different gap studies, and you uncover, I think, many of the problems with non-formal enforcement. So the whole idea of equality, for example, right? So not to say that it's not a problem in kind of more formal enforcement, and there are many researchers suggesting how there are barriers to getting legal remedies in many contexts. So I'm not saying this is, but just I think it's a good way to show how by relying or kind of giving it back, empowering people in a sense, we kind of feel good in what we do, but we end up in a sense helping the strong. And again, this is a very classical Law and Society kind of arguments when it comes to legal access, but it seems to be replicated here. I think the idea of trust is super important. Again, would encourage you to kind of break it more into what trust means. So again, it's a very growing research, and is it about benevolence or about integrity or about ability, or what component of the trust in terms of, for example, what employee sees that is being done following their report. So I think you focus on, and again, this also came up in this other papers you mentioned, that the idea of just protecting the person who blows the whistle. I think maybe also the impact of what's going on following the complaint, what change, and I think if people don't see the change or don't see the change related to them, this probably is more important than everything than just maybe allowing them to be with more protection. I guess also the maybe the broader argument will be kind of sometimes the separation between ensuring compliance and enhancing compliance. So sometimes in many studies around enforcement, kind of there is this finding that we could enhance compliance or show a bit of improvement, but I think the harder question is sometimes, can it actually ensure it? So what will happen if that will be a sole policy tool? Did whistleblowing mechanism convince us that this is the right solution to the fact that you have, both Mexico and kind of different countries, part of the same agreement? Or maybe it suggests that, okay, maybe it can have some improvements, but definitely what we learn is that it's a bit limited as something, and we have to supplement it with other mechanisms. And this is the discussion that I would love to see more, kind of what would happen if other regulatory tools were put in place. What are the obvious advantages, especially as a way to solve the fact that it's kind of, in different countries to report to the US? What other mechanism likely to be better? So I think this is super important. Maybe two more kind of broader suggestion, and again, is trying to maybe connect more to the whole research on intermediaries in regulation research. Again, it's not a literature I knew about before, but increasingly I'm working now with people from political science, and I notice it seems a very kind of promising area, and this could be somehow enhancing kind of whistleblowing, not so much by, I don't know, protecting employees, but somehow bringing in all kind of people who themselves will be in charge, making sure that, not just waiting to hear, but being more kind of proactive and being the people who will mediate the information in a better way. And the last point was kind of I think it's there when you talk a bit about kind of strong versus weak, but I was more interested in the whole international aspect and the kind of the loyalty of each person to their own national laws relative to those broader terms. So obviously here there is the US being stronger than Mexico, but is that the only thing, or there are also things which could be generalized to any attempt to use such platforms, even let's say the countries were in equal power or equal kind of respect for rights? What's the kind of, what do we see here? So I think I will end here. Thank you so much for the opportunity to read the work, and really good luck, and I hope it will come as a book at some point.
So do I respond
Maybe
now,
you
or
want to
do we?
respond now, and then we'll take some comments, or you want to pick up some comments, whatever you prefer.
I can respond really quickly.
Okay.
Those were super generative. Thank you. I would have to write a book to answer all of them. These are 10,000 word articles. So I'm like trying to figure out how to do, wait, was it 10,000? He lives like, not 10,000, maybe it's 9,000. Maybe I'll talk her into letting me do 10,000. However, I found what you said really interesting, especially this intermediary discussion, because incidentally, what I was finding is that those who participated had US intermediaries. And this is actually what made me put them in the privileged category, because they had the Solidarity Center. they had US unions, they had Congress, they had these intermediaries between the enforcing executive office and the facilities in Mexico. So I don't know what the answer is, but I'll certainly, and if you have any of that literature, to blast my way, otherwise I'll look, but that's really interesting. And then as far as supplemental instruments, I have another, as mentioned, I have another piece out that looks at kind of this narrative around empowerment, and what do we mean by that? And are we just, this is like sin capacity stuff. And what I argue, at least in that piece, is that we can't just do the whistleblowing in a vacuum, that it has to be complemented by things like technical assistance from the grassroots, right? So I think I'm less interested, for my purposes, I'm less interested in looking at other top-down mechanisms, and I'm incredibly interested maybe in the intermediary, but even more so, this true notion of local empowerment, not in the narrative context, but in the capacity context. So how do we fully inform these workers of the rights that they are supposed to be receiving, so that they can do a contrast with the rights that they are receiving, coupled with understanding how to use the platform to advance the former, right? That's kind of where my headspace is. I know that there are other places worth taking this, but I'm incredibly interested in how the inequities of trade might be shifted such that the powerful truly are kind of exporting capacity rather than just goods. And in fact, I'm doing another project looking at the drafting history of the GATT. So after the Havana Charter died and the GATT kind of continued to live, what was understood by the drafters when they referred to full employment and when they referred to fair labor standards. And even in those nascent days, there was this firm understanding that you would never be able to achieve kind of the Keynesian ideals of full employment and even global peace if you did not enhance the capacity of workers within trade countries. And so I think that there is a much broader story here. And the challenge for me is how to create a kind of a bite-size, like amuse-bouche kind of thing for the current project, which is why I'm trying to like bite off the whistleblower. But I'm really curious. I think I probably have the capacity to bring in some of that intermediary discussion. So thank you. That's cool.
Okay. Thank you, Desiree. Questions, comments, thoughts? Yes, Jen.
So thanks so much. I think that the empirical findings here are really interesting, and the research is really needed. This is sort of an obvious point, but I think that there is a way in which the paper sort of seems a bit naive about the politics of the USMCA. So, it is interesting that a country that has not itself ratified the ILO conventions on collective rights is essentially the architect of an agreement that attempts to enforce those in another country. And so one might wonder if some of the skepticism on the part of Mexican workers is actually a sort of somewhat informed skepticism, that there is that this mechanism is in the context of a broader agreement that includes things like, the labor content rules of origin that are clearly intended in some sense to provide a degree of protection to, to American labor. So I'm wondering if the research gave you any sense of beyond the skepticism, if there was also a sense that the content of the agreement and sort of the narrow focus on associational rights was perceived by workers as perhaps not necessarily the most important issue confronting them, or too narrow. This was one of the issues that came up in the Bangladesh Accord, where workers felt that there were really pressing issues beyond health and safety, which was the narrow remit of that agreement for understandable reasons, given that it followed Rana Plaza. But it created a lot of tension in the sense that they felt that there were issues around, wages, for example, and other kinds of issues that were, not able to be regulated by this kind of relatively narrow instrument. So this, I think it goes to your really important observation about the degree to which those who are able to use this agreement are those who are in existing sort of relationships with U.S.-based stakeholders, particularly the Solidarity Center, and the degree to which then that becomes, sort of the content of the agreement and its implementation get driven by the interests of those stakeholders. And for that reason, perhaps sort of the limitations or the challenges in a mechanism like this actually leveraging, kind of genuine, organic, kind of empowerment and utilization on the ground.
Thank you. Victor.
Professor LeClercq, great to see you again. Professor LeClercq was my professor at ILR when I did my master's. So this is a great paper. I enjoyed reading. Reading it and learning is a topic I've been very much interested to learn more about. So it was really great to get to read it here in this group. And my question comes from the terminology of whistleblowing versus complaint mechanism and understanding more like a micro versus meso level of analysis. I see the whistleblowing as more agentic micro level analysis and workers being reactive and feeling empowered to report those complaints, and the construction of complaint mechanisms as sort of a more meso level relationship that, in line of what Jen's saying, there is this relationship between the Solidarity Center and the union, the independent unions in Mexico, and then there seems to be that absence, at least in the spaces where workers are not feeling comfortable using the mechanisms yet. So I'm just curious, the benefits and potential explorations that you could do in the paper with some sort of micro versus meso level of relationship. So, yeah.
Cool. Before moving to class, I just wanted to comment that I'm not surprised that Jen and Victor were the first to jump and commenting at this paper, because I think it's kind of an editorial comment. There are a whole lot of strings that tie together these two papers. And, it's kind of nice to start pointing these out towards some kind of a volume that will be coherent, because the papers are in dialogue one with the other. And these two papers particularly, I found to be leading in a similar direction. So that was really nice. Class.
Yeah, thanks, Guy, and thanks, Desiree. So perhaps another question on intersections, perhaps with other papers. So what the paper made me think about or got me interested is the interaction between the rapid response mechanism and other labor regulations and frameworks that are out there and that are coexisting. You mentioned yourself the forced labor ban. And I think one point that seemed interesting to me is that what could be understood as whistleblowing under the rapid response mechanism, so basically workers initiating the procedure, and at the same time this idea of the procedure being a one-off, exceptional, type of procedure that has a clear start and an end. The same form of worker involvement under a due diligence framework could be part of stakeholder engagement that is actually seen to be something continuous and much less only dealing with the exceptional, but actually on a permanent basis. And so we could say that in the forced labor framework, this act, a very similar act by the worker, very similar form of engagement, actually falls under a different legal framework and actually it has a different meaning than whistleblowing, but rather continuous inputting to a due diligence framework. That I think would be true both for the forced labor frameworks and for European style due diligence. So what would be the differences there? And a second question, perhaps you started with this point on data, which I find completely relatable. But on the other hand, we see now growingly these technology-driven worker voice tools, etc. And we could at least, I think, hypothetically imagine that through this, the way to blow, the technical means of blowing the whistle will become much easier. And if that's the case, attention might shift again to the procedural rules under the rapid response mechanism. So is there... For now, the framing was very much around we need to educate them and make sure that there's accessibility of blowing the whistle. Perhaps technology will actually mitigate that, and then it would shift back to the procedure. How would you see the procedural design of the mechanism currently being able or not to deal with a possible increase in the ability of blowing the whistle?
Cool. Blessing.
Good afternoon. Thank you so much for your presentation. And Professor LeClercq, my question is regarding the stakeholder alliances that you mentioned about those workers who felt had a little bit more security in terms of participating in the whistleblowing. So I wanted to ask, I've not read your paper because I got the invite a little bit later. So I just wanted to ask, are these agreements formal or informal? That's my first question. And if they are formal, based on which regulation, what rules, how can they be enforced to ensure that the whatever protections are guaranteed in this agreement can be met in the case where something does go wrong? For example, somebody blows a whistle and they need the security guaranteed in the agreement. How do you enforce this? And secondly, I wanted to ask just like a practical question. How did you approach them to discover how they have this sort of stakeholder alliances? Like, how did you figure out, how did these conversations come about for you to be able to distinguish between those who did and who didn't? Because I believe like it's a very nuanced thing for people to explain like, oh yes, I have an alliance. They wouldn't want to outright say it because they themselves try to protect this sort of agreements or arrangements that they may have.
Thank you, Blessing. May.
Hi, Desiree. Good seeing you. Okay, so wonderful paper. I really enjoy it. So my question goes toward the framing of the paper as private monitoring, and I wonder if it is truly private monitoring, or is it closer to public-private monitoring? Because I think as you describe in the paper, the US government can self-initiate these proceedings. The cases are brought sometimes with assistance, right? Could be with assistance from the US government or the US nonprofits. And so I wonder in practice, is it like how important are these assistants, right? And the reason I ask that is because it almost remind me of so the imbalance power dynamic, right? Not just among the countries, but also within those actors, right? So there's whole literatures on attorney clients, right, and who has the power to drive the litigations and frame the theory of the case, etc. And I wonder if that imbalance is existing even within the strategies of how the case are brought, right? Selecting the case, selecting the plaintiff, etc. All those wonderful litigation-related literature. Thanks so much.
Great. We'll take one last comment and leave a few minutes for Desiree to answer. Rebecca.
Hi, everyone. Thank you, Professor LeClercq, for this very compelling presentation. I have just a small question because I recently talked to an Indian researcher who engages with the trade unions in Indian garment factories. And she had a similar point to yours, but based more on gender-related imbalances. So I was wondering, so in the sense that the use of technology was reinforcing gender imbalances in the Indian, like in the working communities. So I was just wondering whether you experienced the same or where this difficulty was already incorporated and addressed in a certain way. So that's all. Thank you.
Okay, Desiree, you have quite a few questions. I wonder if you freaked out supervising a host of researchers who had to hide from the cameras when there are guards walking with pistols. So
Yeah.
Study, yeah.
Yeah, so I am not the one who administered the questions. That was Alex and Cirila, who are my co-authors and Mexican nationals. It was very important to our team that the people who were meeting with them could be trusted themselves. And so, you know, there are questions of like, well, how did you find the workers? A lot of that was kind of through the snowball effects and word of mouth. Cirila is a longtime union and feminist advocate in Mexico. And Alex is a longtime labor advocate in the auto sector. So through their connections, they were able to meet. The question about how did we find out the associational links was through building that trust and talking with them, as well as my own conversations with the Solidarity Center in Mexico and the Solidarity Center in the United States to have a better sense of what cases are being brought successfully to the United States. May, you mentioned, that's an interesting connection to see the discretion that the government has, kind of like that of a lawyer. And, I actually don't think that takes me, though, out of the whistleblower frame, because if you look at our whistleblower legislation, always the agency retains discretion on whether or not to pursue enforcement based on the information provided by the worker. So, and that was actually what made me use this framework. Victor, I take your point that there might be drawbacks to the framework, right? Or it might be skewing our vision. This is kind of a hat I'm trying on experimentally within the framework of this article to see, because the parallels I find and the narrative and the kind of the priors that come along with that narrative, I actually find are helpful in being able to situate these emerging strategies against a framework that we already know, to say, look, there are parts of it, it's not this completely new thing. It's not this totally new experiment. In fact, it resonates with something that we already have some institutional knowledge about. So what we need to do is apply those lessons that we've learned in this context to this emerging strategy in order to not start over, but rather to build, right? Jennifer, it's funny, I've been called a lot of things. I'm not sure I've ever been called naive about the politics behind the USMCA. We were very aware of what happened during the negotiations. I worked for USTR when we negotiated the USMCA. I'll just mention that the workers we spoke with, and I cannot emphasize this enough, the workers we spoke with barely understood that they had a new labor law in Mexico. To expect them to understand not only what the USMCA was, what exactly it regulated, and then even further, whether they understood that the United States shouldn't be regulating collective bargaining because in the United States, its collective bargaining laws under the NLRA aren't in full compliance with the ILO, and the US Senate will not allow it to ratify a convention under our supremacy clause, I think is about 15 steps too far. The workers we spoke with in Mexico had legitimate concerns about the United States, but it had nothing to do with anything so sophisticated. It had to do with this greater kind of instinct that the United States was probably not enforcing USMCA for altruistic purposes, that it was probably also trying to offset the scales of competition in order to protect its own workers. But we also found that notwithstanding that intuition, they also, about 50% of them, felt that the United States was perhaps doing this because it wanted to make sure that Mexican workers weren't facing substandard labor conditions. And then, I don't think I got to this in the paper, but later questions we asked, would you like the United States to amp up its activities at your firm, lower the activities, or remain the same? And a majority said, we want them to become more involved. So there was this real politic takeaway of our survey results, which was that Mexican workers, while they may not understand the intricacies of the collective bargaining and the hypocrisy there that those of us who have worked in this space forever understand, they realized both that the United States was acting in its own self-interest and that it was in their self-interest to let it do so. So it was a far more complicated type of thought processing than even I realized I myself had been quite parochial in trying to protect these Mexican workers from like the big bad US government, when really, in fact, the Mexican workers were like, don't protect us from that. That might actually help our checking account, right? So it's kind of a complicated story there, but one that I hope to continue. There was a question of like, well, what about other types of strategies? So this, in addition to other types of strategies. So forced labor, I know that the European forced labor bans are different from the US forced labor bans, but what I'm really, really looking at is this pipeline. So in the United States, as well as in Europe, right? Workers can trigger a closer scrutiny of the goods at the border through alerting customs. So both have this, what I'm referring to as a whistleblowing kind of channel. Whether or not there's ongoing kind of deliberations, I think that's great. And maybe more work can be explored in that. That's not in this particular article. But for my purposes, what I'm super interested in is how workers on the shop floor can galvanize this type of scrutiny and this type of enforcement, and how to better kind of encourage that participation. And I'll stop it there because I know we're at time.
Guy, you're on mute.
Thank you so much, Desiree and Yuval, and thanks also for the timekeeping and for a great paper.